Jones Myers is one of the few firms outside of London which covers and deals with child abduction matters under the Hague Convention. We have a specialist team comprising of myself and Kate Banerjee, who are both panel members with the International Child Abduction and Contact Unit London, who are accredited to deal with this type of work. We deal with both applicants and respondents. So the applicants are people whose children have been abducted and brought into the jurisdiction of England and Wales from one of the signatories to the Hague Convention countries, and vice versa. We also deal with respondents, so that is the parent who is accused of bringing their child or children into the jurisdiction of England and Wales from one of the Hague country signatories without the permission of the left behind parent. There are two types of abduction. The first is wrongful removal, and that is where the child or children are removed from one country without any knowledge or consent of the other parents. The second is what's called an unlawful retention. That is where the parent knows about the child going to a different country, usually due to a planned holiday for a set duration, but the child then doesn't return, and the other parent makes clear that they are remaining within the jurisdiction of England and Wales. I think the most important thing is to seek immediate legal advice and watch out for any unusual behaviour that's being displayed. For example, if it's separated parents and one parent normally has the passport, there's no planned holidays, and the other parent says, "Can I have the child's passport?" That may raise some red flags for you, especially if the other parent has connections to a foreign country. So it's vitally important. Time is of the essence with this, because children can be removed from countries very, very quickly to seek expert legal advice. And there are steps that can be taken if it's thought that your child is at risk. Certainly in terms of a removal from England and Wales, applications can be made to the courts for what's known as a prohibited steps order to prevent your child from being removed from England and Wales, or a child arrangement order to set out the arrangements that are in place for the child if the child lives majority of the time with one parent, to obtain what's called a child arrangement order, live with order, which gives greater protection also to one parent over the other.